Good afternoon, everyone, and welcome to Loss Prevention's presentment on impeachments and what these are and why they need to be done. So I'm going to begin by introducing myself as my fellow emolument, and that word is directly affected in every one of our oaths of office, as stipulated right here. One thing you're going to begin to hear is, as we move forward through this process and through many of your constituency, is that I was denied due process of law. Many of them will not be able to articulate what that process is. Well, that's why I'm here. The process that was due me personally here in the state of Florida is this process, and I hope you understand it by the time I get through. So, this is to the left of the screen is me off the clock. You're going to hear me reference off the clock and on the clock multiple times throughout this video, so be prepared for that. My family crest in the upper left, my family's coat of arms in the lower left. The Latin designation in the scroll underneath is as I discover, and as discovery is a right, even in court, let's discover together, shall we? So, reason we're here is this particular interest known as liberty interest, okay, and this is, how it's viewed in law. Liberty interest is an interest protected by the due process clauses of state and federal constitutions. See fundamental rights. So, if rights are the law, and the law of the land is clearly defined as due process of law, what's the analysis? What are the analytic techniques? Here's one particularly used by my office on a daily basis, whether I'm on or whether I'm off the clock. Because as many of you know, are we really ever off the clock, especially as parents? So hence the joke. So I hope you'll begin to see the humor in this as I kind of move along here. So before I begin, I'd like to set your minds at ease as to this presentation will not be containing a bunch of technical babble or incomprehensible word salad, feeling you like your technology is smarter than you are. So, just to kind of get that one right out of the way as we go here, because as a technical guy myself, I suffer this problem quite a bit. So I'm going to try to avoid that at all costs. So, to impeach, beginning with the Black's Law Dictionary, 10th edition, pages 869 and 870 is where this subject matter begins, as so much as it's viewed in the dictionary. So, this is the actual definition that you would read if you were to pick it up and look at it. I've taken liberty of scanning it for you. So, in so much as what it means to impeach, okay, this is the process I was due and was not afforded. So, my understanding of this process is going to be somewhat consequential to many people, both on or off the clock moving forward. So, my job to instruct my representatives, my fellow emoluments, that's you, that's what the letter of the law says. So, in so much as impeachment, okay, starting kind of working my way backwards here, number 4 is probably the most applicable in so much as obstruction, right? Hindrance, impediment, or obstruction, a restraint by means of a lawsuit. So as we get down through here and you start to see the irony of what it means to engage in a domestic violence contract, yes, that's specifically what I said, a domestic violence contract, excuse me, known as a marriage contract, you're going to begin to understand the repugnancy of how every bit of this came into being. So, without reading the entire definition, we're going to proceed from the hindrance, impediment, or obstruction or restraint standpoint, analytical standpoint. So, one of the reasons why I've called this assembly is because this legal principle, a person ought not be judge in his own cause because he cannot act as both judge and party. Now, as a person whose responsibility is to administer oaths of office, I do have limited judiciary powers, hence the term emolument. So, what are impeachable offenses as defined in the dictionary? Well, this is where things start to get a little bit hairy. I'm going to go into the treatise on federal impeachments, which I have bookmarked some of the pages from that particular treatise, which will also help you better understand beyond the Jefferson's manual, where it is pretty much kind of a short version of what it is. You know, it's the limitations of impeachment being only the removal of office. Okay. So keeping that in mind, okay, how does all of this work? What is your role? What is my role? And so on and so on. So, in so much as a formal impeachment, this is basically the discrediting of a witness's testimony by confronting the witness with his or her specific untruthful acts, prior convictions, prior inconsistent statements, or the like. This is the probably going to be the premise from which you're going to, many of your constituency are going to be approaching you. Okay. The other one that you're going to hear quite a bit of from the constituency is impeachment by omission, a lie by omission, right? And as we've discovered throughout this process, exactly how strategically these actors, known as bar members, have significantly hidden relevant evidence and testimony that was critical to every single one of these constituents you're about to interview. So keep that in mind. Okay. The Declaration of Independence refers to that being reduced under absolute despotism, which I'm going to explain as we go. So the use of a significantly incomplete statement on an earlier occasion as a prior inconsistent statement. So much of this, as we view it in the private sector on the clock, is it kind of comes from this 16th century definition, impeachment of waste. Okay. Again, you know, you hear waste in government. Okay. One of the elements of my job was to deal with waste within the corporation. So this is an action for waste against the tenant of the harmed property. So, for example, this is a concept we use in dealing with things like known theft. So, kind of give you an idea of what that is. So, impeachment verdict, which is a party's attack on a verdict alleging impropriety by a member of the jury. Well, this definition may become expansive as we go along. So I'm going to leave this to your interpretations as you, the members, my fellow emoluments, are technically the jury. So, because all trials of impeachments are to be held in the Senate, right? So articles commenced in the House, trials commence in the Senate. So this is where the board of directors, that you come in. So predicating this grievance pursuant to the following due process of judicial civil rules of procedure as follows. So we actually have a list of these. The first one is failure of consideration, injury by fellow servant, contributory negligence, and of course, release. Knowing and understanding that under Federal Rule 12, preserving these defenses is also critical. So in the analytics of the context of fraud, okay, we can take this and implement this particular maxim of law. A person acts contrary to the law who does what the law prohibits. A person acts in fraud of the law who, without violating the wording, circumvents the intention. So knowing and understanding, for example, the intention of the seatbelt law was not to be used as a means to pull people over. It was to be used as a means to implement a lesser sentence for a moving violation. So where this click it or ticket crap came from, I'll never know. That's enforcement for money, which was one of the things that was specifically litigated when that law was passed. Don't take my word for it. Go back through the congressional record and check it for yourself. So, as mentioned above, the list of the rules, right, those defenses, as viewed even in courts. Many of these, the ones in black are the ones that I chose. Okay, contributory negligence, failure of consideration, injury by fellow servant, and of course, release. So, in so much as fraud, illegality, and statute of frauds, okay, many of those things are going to also fall under the res judicata category. Bar members are going to say these are statutes of limitations will apply. Wrong. There's no statute of limitations on fraud. Go all the way back to United States versus Throckmorton or Hale versus Hinkle for confirmation as to why that is. Excuse me. So, in so much of the discovery of fraud, if the person was in position of emolument at the time, right, such as subordination of perjury, well, that's an act that can only be committed by one of our fellow emoluments, period. Right? So, I hope this is not that bad thus far, or at least not caused to WYSIWYG out like this poor guy. So, any of you young guys or girls out there who want to know the signification of this, go talk to one of your older members. You'll understand they'll tell you what a WYSIWYG is and how WYSIWYGing out became kind of an inner office joke. So, anyway, moving on. My knowledge and skill maintaining the integrity of a corporation and all of its transactions and all of its processes as we worked in our specific categories all day long is one of the main fundamental reasons why the court granted me standing to do this job. This is not about an argument between my ex-wife and I, and all about emoluments violations, which I have discovered and will be readily available to you on a different platform in a different time. This is not the time or the place. So I'm here to specifically talk about how do you deal with somebody in position of emolument. Well, knowing and understanding that the word has been strategically left out of jurisprudence for probably the last 5 or 6 decades, you're going to understand the signification of why we chose this jurisdiction as opposed to 42-1983. One of the main concerns that I was, that of course befell upon me once I'd realized what was actually going on was the preservation of the 4 charters of liberty, right? Magna Carta, et cetera, et cetera, et cetera. So that worked their way up through the 6th Amendment to United States Constitution, supreme law of the land, minimum due process. So this is the reason we chose this jurisdiction. Okay, so this is basically in the private sector, what we do when we do end of day, like we close a store down, right? And the manager goes in and pushes that end of day button. It takes a snapshot, right, of that day's business. And then that day's business is transmitted electronically for review in the company. And of course, its numbers and all of its transactions are, of course, they run through the check and balance mechanism. Many of those programs, I participated in creating over the years. So that's why I said knowing and understanding code the way I do, excuse me, was very significant as to, looking for little minuscule, typographical errors, for example. These 2 documents are examples of, 2 typographical errors, nothing to set the smoke alarms off over or cut the state off, right? But this is just basically, the signification of what Section 405 actually enables us to do on a daily basis. So I hope that kind of, knows and helps you know and understand. So what is color of law, right? Stemming from this word, okay? And what are pillars of law? Well, we're going to examine that. Our republic, right? And this word, right, in its singular form, right? Any advantage, profit, or gain. Now, my oath of office, as well as yours, is in its plural form, right? It has an S on the end of it. So again, this means a certain amount of caution is to be, utilized at all times. So if I were to assign a legal principle or a lawful principle, those principles of law that we don't need to litigate, right? These are those ideological principles that we utilize every day. So in order to rightly comprehend a thing, it is necessary to inquire into the names. For right knowledge of things depends on their names. When I sent my original parliamentary inquiry to the United States Congress, Bill Barr's answer to that was a stipend attached to some office. So now we know the signification of the difference between a subsidy and a stipend. So stipend is payroll, by the way, for those of you guys who don't actually know what that was. So in order to understand color of law, we have to understand where it comes from. It's established through the diction, right? The letter of the law established by constitutions. So the other element of that, the juris, which is the methodology of application, color of law. Okay. So you're going to also hear a lot of that color of law crap doesn't apply to me. Technically speaking, if they're not on the clock, they're the managers of those of us on the clock. That's what being in service to your constituency actually means. So now that we have jurisdiction, the color of the law and the letter of law, right? This is what 56 of the smartest men on the planet constructed when they constructed our government. This is people ask you if you had to be asked what the republic would look like if you were to model it. This is the model. Okay, so now that we understand that, jurisdiction, right? Color of law, letter of the law. This stems, right? Stemming from points of authority, right? Or pillars of law, right? So at each point, okay, there is a pillar. The branch stems from that pillar. I hope you guys understand that. In so much as where a corporation comes into play with this. Well, you recognize those, me on the clock every single day, right? Market, margin, and capital. This is our constant communications between my offices and yours. So that's mandatory oversight. That's really, in essence, what this is. So you've seen many things come from many offices of loss prevention, things like material safety data sheets, and of course, capital gains reports, market analysis, and for example, the profit margins, excuse me. Those are things that are protected under Hale versus Hinkle. Kind of give you an idea of the signification of what leg Hale versus Hinkle protects and reinforces. United States versus Throckmorton is kind of the combination between the other two, right? So proceeding from more of a high school algebra class perspective with respect to solving simple fractions using the lowest common denominator principles. Well, in so much as medicine, law, and religion, Latin is the common denominator here, right? So now that we understand what the common denominators are, if we're going to apply mathematical principles, as you can see, this is how my brain works. And this is the signification as to why I fundamentally understand this, probably better than most, and of course, why the court granted standing. They know it. They know that I know it. What none of us know is how many of you don't know it. And if you don't know it, my job is to teach it to you. So Now that we understand what the common denominators are, we know what to look for in the code, right? The things that belong there, things that would promote things that don't belong there. You've heard the president speak about Joe Biden's horrible crime bill, the Brady bill. Go read that at your leisure. Basically, that's an attack on the Brady standard. Mandatory discovery. So, which would be exculpatory evidence in a criminal trial. So there's the signification of how they politically, you've heard me talk about political acts of domestic violence. Well, that's an example of one. So now that we understand that Latin being the common denominator, I'm not even going to, need I breathe one syllable on this subject. You're going to hear this from more people, and I'm not even going to go into it. I'm not a doctor. I'm going to tell you to seek doctoral advice on this. So let's go to the state law, right? We're going to apply a principle of law to state law. How would we do that? Well, here's a good example of one that I chose. The torture or twisting of laws is the worst kind of torture, especially to somebody who doesn't even understand the concepts of what a common denominator is. The problem, the inherent issues with education, we'll deal with on another level at another time. So, Article 1, Section 5, the right to assemble. Where there is a right, there's a remedy, right? The people shall have the right to peaceably assemble to instruct their representatives. That's why we're here. And of course, to petition for the redress of grievances. So of course, now that we've gone through what that petition looks like, what it's predicated on, and why, right? And this is the instruction part of that. That comes from Section 795 in the book, right? Investigations in public order, right? In order and investigation into the bodies. Now, number 10 on page 563, I probably should have put that in this presentation, is an investigation into the management of the various institutions of the state, and the departments of the state government is at all times a legitimate function of the legislature. So if you get a bar member telling you this is not your job, they're lying to you. And there it is right there in the book. So you don't need any existing rules. You've got the book. Beat them in the head with the book and tell them get out of your office. So the letter of the law, the right to work. That's what I do. That's the signification of that logo in the upper right corner. Now, the right to work is basically, in so much in the context of this mandatory oversight is the right of a person's to work shall not be denied or abridged on account of membership or non-membership in any labor union or labor organization. That includes the bar. See Sperry XRL versus the Florida Bar. It's already been litigated. He is worthy of honor or office who with much labor and industry has made himself familiar with the laws of his country. There's a principle, a lawful principle to attach to Article 1, Section 6. So I'm going to, again, if we're going to be impeaching ourselves here, there's a good one to, there's a good principle to employ for yourselves or for ourselves moving forward. Page 17, Section 7, numbers 1 and 2. By the way, Section 405, error and mistake that I have to correct. The document actually says numbers 1 and 3, so I actually had to correct that. So thank you to a constituent for pointing that out to me. Anyway, the constitutional provisions stand on a higher plane than statutes and are mandatory. See Peterson versus Peterson as to why statutes, codes, rules, regulations, and guidance documents are not law. They're not law. They're pretended acts of legislation, period. And that is business that was conducted relative to those who participated in it. If you didn't participate in it, you're not bound to it. End of discussion. Hence the reason lawful business requires a quorum. So, if a Congress or a state legislature violates a constitutional requirement, the courts will declare its enactment void. That means void ab initio, void from its inception. And as we get through this, fortunately for me, And fortunately for every single one of you, this happened during the actual time of the O.J. Simpson trial. Many of you were probably still in maybe high school, college. So guess what? We're going in and we're going to clean up their errors and mistakes, right? So what were those errors and mistakes? So the reverse engineering of the Declaration of Independence, right? It is a cursed construction that corrupts the text. And of course, what is illegal ought not be entered under the pretext of legality. What does the Declaration of Independence say? Government's long-standing should not be changed for light or transient causes, right? As many times at work as we've fooled around with this line from the Declaration of Independence, of course, we joke about it. I wonder what the object was and what the hell the design was. It used to drive us crazy. We drive ourselves crazy thinking about it. So here's what it was. Having had to solve the riddle of the Declaration of Independence to get it through their thick skull, now you understand why the court granted me standing significantly. So when I said, you mean to tell me I've been entered into a domestic violence contract? Do you see the stuff that usually is the stuff that hangs on my wall, these credentials? I can't enter into a domestic violence contract any more than I could enter into a contract to to break some other law. That's the dumbest thing I've ever heard. So, in so much as these multitudes of offices sending hither swarms of officers to harass our people and eat out their substance, right? Child support, for example. I've done the audit. I've submitted the audit to many of you. 80% of the monies that were paid were stolen by these bar members. So I'm just going to call those what they are, as ill-gotten gains. I'm sure you've heard your grandparents talk about what ill-gotten gains are. Well, there they are in law. Okay, so Peterson versus Peterson, as I said, right? This is the Social Security emolument scam, right? Guidance documents, policy, and all that crap. It's not law. It's garbage. You can drop it in the shredder. I called it shit made up. I mean, what else do you call that? Because that's what it is. I was at work during when all this happened, and as I said, many of you probably were still in school. So here's the signification of how of the demise of my marriage. I'm going to share a little something with you. One of the biggest fights we had was, I used to, was trying to explain what it took to keep the machinery of the house going while I was putting her through 4 years of college, right? So now knowing and understanding what color of law and jurisdiction is, right? That not being able to articulate that at the time, that was my fault. So again, introspection, start from within. So now that I can better understand that and I can better articulate that, at least moving forward, I hope she knows that this was nothing that was intended on her. So fraud upon in Bullock in 1985, the court stated fraud upon the court, right, is fraud which is directed at the judicial machinery itself and is not fraud between the parties or fraudulent documents. Now, again, you're going to see your constituency showing you dictionary definitions to the contrary, right? So knowing and understanding that the level of the work that went into this project, this research and redevelopment, right, of the law, starting with zero, the Declaration of Independence, I ended up in having to solve that riddle, right, which is consistent with this decision. So I hope this helps you better understand the level of detail that went into this project. So Section 16, where there is more than a mere technical violation of the rules of procedure. The violation may invalidate the act, and of course, an act will be invalidated where there is fraud or bad faith. So whether you want to call it fraud or whether you want to call it bad faith, again, tomato, as far as I'm concerned, just get rid of it. Article 1, Section 10. Now remember, this is state law, Florida state law specifically. Prohibited laws. This is stuff that we couldn't do if we wanted to. No bills of attainder, ex post facto law, or of course, law impairing the obligation of contract shall be passed. Now, why is it that the bar members have been exploiting this section of the law? Well, they entered into this domestic violence contract, and now they're subject to management by all of us fourth and fifth pillar actors. Yeah, tell that to me. Have you met my wife? Yeah, moving on. So, always in doubtful cases, that is to be done by which a bona fide contract may be the safest condition, except when it has been drawn up clearly contrary to the law. So you want to know how to get rid of these marriage contracts? They clearly fall within the category marked yellow here, right? They have been drawn up clearly contrary to the law. So hence zero, right? There's zero equitable interest in this crap. It's garbage, right? So insanity prevents marriage from being contracted because consent is needed. It's another maxim of law. It's on the cover page. I'm sure you've probably gotten a giggle out of that. So Section 459, this is where we go back in and reconsider, right? These are reconsiderations. So this is why when I've called both houses into assembly, employ Section 459, number 5. So when the two houses are meeting in a joint session, they have the right, as long as they're in session, to reconsider any question they have had before them or any vote they have taken. That's anyone. So if anybody, you can't do that, you can't do it. Want to bet? I'll show it to you right in the book. So in so much as correcting errors and mistakes, removing this stuff, how do I, what's the mechanism, the mechanics, how do I do it? Well, you can blame it on Howlett. That's, again, I don't mind playing bad cop. It's actually kind of fun. Section 459, number 5, and say, have a nice day, get out of my office. You can also utilize the courts because they are a co-equal branch. Page 353, section 517, number 1, no motion or measure is in order that conflicts with the Constitution of a state or the U.S. Constitution or with treaties of the United States. And if such a motion or measure be adopted, even by unanimous vote, it's still null and void, meaning void ab initio from its inception. Right? Void ab initio is, of course, the Latin. So that's why I said getting into common denominators again. And so I said sometimes this is a little bit of a my brain reflexing itself, but it is what it is. Article 3, Section 11, prohibited special laws. Okay, there shall be no special law, right, or general law of local application pertaining to number 15, divorce, period. So if you can't create any specific special law pertaining to divorce, what does that do to the marriage contract? So, again, the contract itself is void from its inception. It's crap, it's garbage. Why? What is illegal ought not be entered under the pretext of legality. That's on the design plan. A special law detracts from the general law. And of course, as I just said, insanity prevents marriage from being contracted because consent is needed. So I said, hope you're having a little fun with this. So Section 245, submission of point of order, right? Points of order as viewed in the private sector. Judicial orders are, again, points of order. So many of you are going to be receiving judicial orders that they appear to have been spurned from the throne with contempt, right, by these bar members and their fifth pillar administrative officers, right? They don't want these people telling on them. Well, guess what? It's my job. It's our job, collectively speaking. So a point of order is decided by the presiding officer without debate unless, in doubtful cases, the presiding officer submits the question to the body for advice or decision. Again, each one of these is going to be at the presiding officer's discretion. If you would like help from myself or my staff, please by all means reach out. Contact information is readily available. I speak to state legislator offices constantly. So again, I make myself readily available to you for anything you would need. So we go through the definition. We know what Article 1, Section 6, Clause 2 is. That's the emoluments of our collective offices. That's the stuff the Constitution creates. So why does Article 1, Section 9, Clause 8 not have a clear definition in the law dictionary, especially knowing what the letter of the law states? So again, beginning with supreme law of the land, minimum due process, let's establish a minimum here, right? So here's the letter of the law, right? And the correct 13th Amendment. And this is where the bar members' heads explode. So guess what? Again, I don't mind playing bad cop. It's one of my favorite jobs on the planet. So anyway, moving forward, Space Force argument notwithstanding, of course, the no title of nobility, blah, 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 blah. Yes, we don't, titles of nobility are ridiculous. It's the foreign pillars, foreign powers, right? That's the signification of the exclusion, right? The creative hiding, if you will, of the actual 13th Amendment. And of course, we've verified this through the legislative record and through the Library of Congress. Many different organizations, as well as my own, have proven this. So this is the letter of the law. Too bad, so sad. Fourth pillar, fifth pillar. See you, bye. So, Amendment 1, Congress shall make no law respecting an establishment of religion. This stems from the Declaration of Independence. Governments long-standing should not be changed for light or transient causes. What's the fifth pillar ideological of Islam State? They're on their pilgrimage. That's a transient cause. Makes it repugnant to the letter of the law. Hope you understand that. And of course, to petition the government for the redress of grievances. So again, we have state law, we have federal law, right? We have minimum supreme law of the land, minimum due process on both of those accounts. Good, satisfied. Now, treatise on federal impeachments. This is where things start to get a little bit well, let's see here. Going to go back to this treatise on federal impeachments. Here we are. So the signification, okay, is beginning on the page 21 of the treatise under Article 4, Section 6. The House of Representatives shall have sole power of impeachment. This sounds a lot like the Jefferson's Manual, correct? So that's where the articles are generated. Section 2, he, the president, shall have power to grant reprieves and pardons, but his pardon shall not be pleadable in bar of an impeachment. He shall be removed from his office on impeachment by the House of Representatives and conviction in the Supreme Court of treason, bribery, or corruption. I hope you now completely understand what's been going on in Washington as we move forward. So, Article 3, the jurisdiction of the Supreme Court shall extend to the trial of impeachments of officers of the United States. In cases of impeachment, the jurisdiction shall be original, right? So this is why specifically in the recent impeachment, when President Trump was impeached, Justice Thomas was brought in. So there's the signification of why Justice Thomas presided. Moving forward onto page 25, Mr. Morris thought no other tribunal than state could be trusted. The Supreme Court were too few in number and might be warped or corrupted. He was against a dependence of the executive on the legislature, considering the legislative tyranny, the great danger to be apprehended, but there could be no danger to the Senate, would say untruly on their oaths, right, our oaths of office, that the president was guilty of crimes or facts, especially as in 4 years, he can be turned out. So again, when it gets to dealing with political stupidity, right, there's checks and balances built into this already. That's the reason that I'm even going over that. So what we have to watch out for is the corrupted mechanism, right? So the signification here on September 14th, 1787, when that report was under consideration, Mr. Rutledge and Mr. Governor Morris removed that persons impeached be suspended from their office until they be tried and acquitted, right? So when we discharge the duties of our offices, right, we're not supposed to be assigning bills of attainder. We're supposed to be discharging the duties. See the signification and the differences here? So this is specifically why in loss prevention, for example, the known theft thing, those, when that comes out, part of the discharge of that duty is to, in the write-off process, right? That's the reason it requires a mechanism to discharge that loss. So knowing and understanding what writing all of that code meant, right? Because I knew what it needed to do. It had to be done clearly, concisely. So if we ever did get audited, oh, okay, yeah, that's easy to explain. So, so I said, when the wife said this was literally Dad's job, she had no idea how correct she was. So the Senate, then being a court right now, because we're talking about, the signification, you're not making law. Law of the land literally means due process of law. What we should be doing is we should be impeaching this garbage. So again, you, me, we've all been lied to. So the Senate being a court, or proceeding as if it were, certain necessary consequences follow, which usually have been recognized and accorded. And okay, we're going to get into I'm going to get into those because those are significant. The respondent is entitled to be informed of the nature and cause of the action against him. You have the right to face your accuser, right? Hence, as I discover, he is entitled to have the assistance of counsel for his defense. It says assistance of counsel. This has nothing to do with the Florida bar. So I hope that clearly understands the signification of why Florida bar members really, technically speaking, have no standing in this process, right? Their presence here from the fourth pillar is a usurpation of any involvement they have between the third pillar of the judiciary and the first and second pillars between the legislative and the executive branches. If for a very good explanation of this during one of his last oversight hearings, separation of powers was an extreme concern, let's just say, for Justice Scalia. Read as many of his separation of powers document, as much of his separation of powers documentation as you can. He lays that out specifically for you. So, and in so much as the rest of these, this is why the people are, again, you get into some of these principles, right? For example, the fifth, he cannot be compelled to be a witness against himself. That's the Fifth Amendment, right? So, again, as we go through here, this is, as I said, page 36. So these are the criteria, right? 8 criteria, 8 elements that must be met, right? So knowing and understanding that this is our job, this is our process of impeachment, okay, we can go into, oh, I'm sorry, there are 9, my bad. Section 405, errors and mistakes. I make those all the time, as you can tell. So, and of course, finally, the 9th is reoccurring again to the Constitution, right? If once acquitted in impeachment proceedings, he cannot be subject for the same offense to be twice put in jeopardy. That's res judicata. So again, that's the reason that defense has made its way through the court in so much as the court rules. So if we're looking at this from a gubernatorial standpoint, that being the president, right? The governor, the president, same, shall have power to grant, excuse me, reprieves and pardons for offenses against the United States, except in cases of impeachment. Okay, so under Article 3, Section 2, which provides the trial of all crimes except in cases of impeachment shall be by jury. The right of trial by jury is going to be preserved, whether anybody likes it or not. They're not going to administrate rights. They're not going to administrate law. Period. Not going to happen. Administrative duties, on the clock in the private sector, that's a different animal. So you want to know why many men in particular have walked away from the whole thing of relationships. Well, you're not going to get me to engage in a contract that promotes domestic violence, and then you're going to tell me you're going to manage me? Horse hockey. So, 2 other cases have a direct bearing upon the question at issue. At issue. In state of Nevada versus Borowski, the public administrator was indicted for the appropriation to his own use of funds of an estate in his charge. The statute upon which the indictment was founded provided, for any unlawful misdemeanor in office, any public administrator may be indicted, tried, and if guilty, fined any sum not to exceed $2,000 and removed from office. And again, once they're removed from office, they can't hold another office. That's the signification of why these actors don't want you to know how to do impeachments. Because once they're removed from office, they can't be, you can't hire them again. Period. It is what it is. This is the element of how deep the corruption runs. So, in so much as can one be impeached after he has ceased to be a civil officer of the United States? This section, starting on page 70, will kind of outline this for you. Again, keep in mind res judicata. So, also keep in mind there's no statute of limitations on fraud, right? So if there's no statute of limitations on fraud, okay, person's already out of office, you would just impeach his or her actions, and then they can still be tried criminally. So, I mean, either way, it is what it is. So, in so much as the first, right, the first provides judgment in cases of impeachment shall not extend, excuse me, further than to removal from office. And of course, disqualification to hold and enjoy any office of honor or trust or profit under the United States. There it is. That stems its way from Article 6 of the Articles of Confederation up through the emoluments, the Foreign Emoluments Clause, Article 1, Section 9, Clause 8, and the original 13th Amendment. There it is, right there. So this is specifically why the relearning of the impeachment process is significant to ward off foreign powers, foreign emoluments. This is a republic if we can keep it, right? So let's do that, shall we? Because like many of you, I have much work to do, and I'd rather love to get back to it. So the signification moving forward here. Section 53 on impeachments, right, from Jefferson's. This is the parts that I was just reading directly from the treatise on impeachment. So, House of Representatives shall have sole power of impeachment. That's where the articles come from. And the Senate shall have sole power to try impeachments. So, insomuch as the process that I was not afforded, this is it. So, again, funny how things just come back to be full circle, isn't it? Insomuch as the actual outline of the process, again, the jurisdiction is laid out. Okay. The entire explanation of jurisdiction is laid out in Jefferson's manual. How the accusations work, right? The Commons, as the grand inquest of the nation, be suitors for penal justice, right? So again, when all political power is inherent in the people, this is our job to do it. They're pissed. Our job is to do what it is they're supposed to be, what it is to investigate, go through, and crawl up the rear ends of these bad actors with a microscope. And you're going to find out I'm very good at this. Very good at this. Companies paid me good money to do this. So what the process is, what the articles are, how appearance works, right? There's rules for how we, bring these people into oversight, right? Do we need to bring them in, or what is it? Do they need to be in an in-camera meeting, right? How is this going to work? It's going to depend on the actor. It's going to depend on the offense. So how they answer, right? Once they've appeared, how they answer, right? And of course, replication or joinder. Replication or joinder, you may want to pay very specific attention to that with related to many of these, how deep a lot of this corruption goes, and plug in the business model, the foreign business model, that Sharia law stuff that I've submitted, and run that back through the program, and you're going to see how many red flags pop up. That thing's going to light up like a freaking Christmas tree. Expect it. So, knowing and understanding that the jury of their peers, well, that's us, right? They're in position of emolument. They've claimed and exercised powers they don't have from pillars of law that don't exist here, right? So knowing and understanding the signification and the extensive labor intention, I'm ready to hold my beer. I'm ready to go. Let's do it. So presence of commons, right? Should the people be present? Absolutely. Absolutely, if the people wish to be present personally. The people have the right to be present. Here's the case's signification. So if somebody obstructs justice, right, whoever is guilty of the obstruction, they're to be impeached, whether they're receiving a stipend or not. If they're claiming that their position, that's decusius, by the way, their position being there, right, is subject to challenge. Who are you and why are you standing in front of me? Okay, you're still impeaching that person's position. It is what it is. It all boils down to impeachment. End of discussion. So let's learn it. Let's do it. Let's get it done. Insomuch as judgments in Parliament for death have been strictly guided per legem terrae, which they cannot alter. Right? It is what it is. So in cases of death, this is the process. It's specifically laid out. So again, that we're going to end up probably leaning on many prosecutors to do their job. And they're going to be doing it from now on under strict scrutiny. Trust me. So moving forward, let's apply some of those principles of law, right? Signification, right? If we're talking about what are the significant causes or these principles, this ideology, A person ought not be judge in his own cause because he cannot act both as judge and party, right? Fundamentally, principally, these are things we know. A judge cannot be a witness in his own case. Actually, I didn't know that until I actually discovered that in the law dictionary. I guess I always knew it, but I hadn't actually been able to articulate it until now. So it is unjust for anyone to be judge in his own cause. That includes me. Fundamentally, principally, there it is. I know this. So a judge cannot punish a wrong done to himself. So being in position of emolument, having judiciary powers, I don't have the power to do what some of these people have asked me to do. I know that fundamentally and principally. So in so much as why it requires a quorum, what I cannot do in my person, I also cannot do through the agency, meaning through a contract of another. So hope you enjoyed this presentation, because in so much as what's actually been going on over about the last 5 decades, right? Again, establishing liberty interest, right? Family crest, the analytics of what we've just done here, and of course the Florida state law. This representation is specifically what Abraham Lincoln was talking about. A divided house cannot stand. So how do you divide 3 evenly, knowing that 3 is prime? Here's the math. I've taken and laid it out for you. So this has been an agenda that's been going on for a long time while we were at work. Some people knew it. Many of us didn't know it. When I discovered it, you betcha I'm going to beat them to death with it. So hence the reason why I'm beginning to have quite a bit of fun doing this. So Jefferson's manual, right? Page 30, I'm sorry, section 33, my bad. It is proper that every parliamentary assembly should have certain forms of questions so adapted as to enable them to, fitly to dispose of every proposition which can be made to them, right? We are supposed to be disposing of these duties. This is our jobs. So the question is to be put first in the affirmative and then on the negative. Again, as you read my judiciary practitioner's report, in my original amicus petition, which I worked with another licensed professional, he did an audit of 18 states of what being spurned from the throne with contempt actually looks like, and how these bar members use that mechanism for infighting. Again, as George Carlin said, it's a private club and you ain't in it. Well, that's what he was talking about. So, so much as my parliamentary inquiry, what emolument is that? Right? That is, in fact, the question, isn't it? So thank you for your attention, and I hope you found this content both helpful and a little entertaining considering the subject matter. So with that, I'm going to